using high officers of the police to harass the ED officers to make sure that the evidences are destroyed. So I think that this is a very serious case, and I hope that the courts, they, with all their wisdom, they take very serious action against Mamata Banerjee. This is no way in which the powers of a chief minister can be used in such a way. So this, it quite clearly, I think it says that when they say chor ki dadi mein tinka,
yes,
she's behaving in that way.
All right, we're getting breaking news, in fact, now coming in. We're learning that the hearing has begun. The High Court is hearing petitions filed by the ED and Trinamool Congress in connection with the central agency's recent raids on the premises of political consultancy firm IPAC. So the hearing has begun now in the Kolkata High Court. The hearing has begun. What are your expectations from today's hearing, Rajlakshmi Joshi?
Oh, I hope, like I said, that a lot of the court, and there will be serious action. So we can't really expect the orders to come within a day. But then I'm sure that a lot of things will be revealed. Like I said, there is a huge case behind this. There is this thing about the coal smuggling scam, which has indirectly, and they have transferred these via money laundering to IPAC, which in turn has probably used these funds for the elections in Goa. So it is all connected, and there are very serious allegations against IPAC for having similarly done something, some cases of money laundering in the past in Andhra Pradesh, while they have indulged in money laundering with YSRCP as per TDP's allegations. So I think that the ED is entitled to conduct all these inquiries and investigations, and if I hope that they are able to put across all these facts, and that the court is able to take some very serious action against Mamata Banerjee. Even in the past, we have seen that she has used her high offices to halt a kind of action by CBI officers, by ED officers, by ration officers. All of this, she's using all of this very indiscriminately, and I think that this is something, there has to be an end to all of this, and especially in the face of elections coming up in West Bengal. So this, quite clearly, she's doing all of this because she is saying that IPAC is her election office. It is not so. It is a private entity. It is not the registered office of the TMC. So she cannot say that she can just walk in there and collect her files. Even if it was a registered office of the TMC, her own political party, in the middle of a raid, she cannot just walk in. So I hope that the court takes observes this very strictly and take very strict action against her, Uday.
Okay, let me also bring in now Vineet Jindal, Supreme Court Advocate. Vineet Jindal, the hearing has begun there in the Kolkata High Court. We, of course, had accessed some of the ED submissions before. We're putting it out for our viewers point by point. All said to be a very important hearing today, isn't it?
Yes, definitely, because this is not a small matter. It is about obstruction of an investigation agency, a central investigation agency who has been going to investigate a very sensitive matter. It is about a political party. It is about the corruption which has been allegedly has been done by some political party. So I think this is very important hearing, and we have already been on your own channel. You have already been discussed, and your viewer must aware about what was going on during that raid which has been done by ED in a private firm, and it is very shocking for everyone who has been seen that particular glimpses of that particular place during that raid. Sitting chief minister entered to an premises and snatching all the documents and phones and creating havoc over there, and to obstruct this investigation which has been carried forward by ED. So this is very shocking incident for everyone, and I think that is very important hearing right now which is going on before the Kolkata High Court, and we have to see what direction has been put forward by the Kolkata High Court, because this is something like overreaching the power of sitting CM, and obstruction of has been done by this particular lady for a central agency who has been investigation this matter.
All right, we're getting more details now coming in from the courtroom. We are learning that the Deputy Solicitor General appearing for the ED has told the court that the CBI and Union of India are not being allowed to come in. He has said that the Advocate General isn't being allowed to enter and the CBI and Union of India must be allowed. So an assertion being put forward, Radlakshmi Joshi, by the Deputy Solicitor General appearing for the ED, that the CBI and Union of India are not being allowed into the set. Lakshmi, can you hear me? Okay, I think we've lost her there. But Vineet, the Deputy Solicitor General's assertions coming in, what do you make of them?
This is also very shocking because it is the matter related to a central agency, and if the Attorney General has not been allowed to enter in the premises, court premises, and not allowed to be argued matter, this is really shocking. It is again a kind of the act has been done by the state government which has been clearly specified that how the people and all the agencies has been put pressure by the government to stop central agency for doing any kind of investigation against central of a state government. So this is misusing of power, specifically when it is about a matter authorized person who has been to argue that matter and not allow to enter even a court premises and argue the matter. This is again against the constitutional fabric of the country.
All right, and further breaking developments also coming in now. Senior Advocate Menaka Guruswamy, speaking for the West Bengal government, has said that this is an extraordinary sign of bullying. They first conduct the raid, now they don't want us to argue. We are not party to the ED application. So now a defense being put forth by the lawyer of the West Bengal government, Vineet Jindal. Menaka Guruswamy is saying that this is an extraordinary sign of bullying.
I don't think we have already been aware about what is going on in the state and how the Mamata Banerjee has been obstructing the investigation agency to put their do their work. So it is not about any kind of bullying or anything kind of this. This is the vague argument. I think their sole intention to just to take dates and to linger on the matter. Because if the hearing could place, definitely there would be some direction put forward by the court. So it will be very hard and harsh for to maintain these particular things by the state government. What I have learned the way the argument at High Court right now, it is just about to ignore the hearing and trying to trying to linger on this matter. There's nothing else.
All right. Meanwhile, the Supreme Court bench hearing the matter has now stated that as far as the ED matter is concerned, the petitions before the Supreme Court are almost identical. Additional Solicitor General S.V. Raju has stated 2 matters have been filed before the Supreme Court making the same prayer. So, a prayer being made now by the ASG, of course, also saying that the prayers on the ED case are similar as to what has been filed before the Supreme Court as well, Vineet Jindal. That is what the Additional Solicitor General is saying. The 2 matters are pretty similar.
So I think their contention is that they are wish to argue this matter before the Supreme Court, because now this is before the Supreme Court, and maybe it will be 1 or 2 days the matter would be listed before the Supreme Court, and it is in a higher court. So definitely the kind of atmosphere right now in the Calcutta High Court is kind of the state government has put their all power just to stop the to stop about the investigation agency, the officer of the central government. So it is a kind of hostile atmosphere in Calcutta. So I think what I have I can say and learned about this particular argument, the Attorney General wants to argue this matter before the Supreme Court, because now the matter has already been reached the Supreme Court and the High Court, but there is no stay. But that's why the matter can be heard on the both sides. So I think they wish to argue this matter before the Supreme Court. That's why this particular argument took place.
Absolutely. That's of course that's what we are sensing from what the arguments are being made by the ASG. Now dramatic developments of course coming in. All right, now Additional Solicitor General SV Raju has responded to the TMC Council stating, how can we say we are bullying? Let me place on records the petitions filed before the Supreme Court. So bullying charge being put forth, Radhakshmi Joshi, by Mamata Banerjee's lawyer, being rebutted by the ASG. Meanwhile, he of course said earlier as well that there were obstructions, that certain parties were not being allowed to enter.
It is ridiculous that the TMC could be accusing somebody of bullying when they themselves behave like the biggest bullies. So they are actually doing blatant misuse of power. And like I said earlier, using her position as the Chief Minister, her high offices, very violently every time there is some action against her. So this is something that is ridiculous, and I'm sure that the ASG will be able to very efficiently rebut all these claims. And I hope that whether it may be in the High Court or whether it may be in the Supreme Court, that these cases will definitely see justice, and that these are very serious cases, charges like I told you. And the ED actually, under PMLA, they could have definitely arrested the people involved. But then they are very meticulously following the due process. And in spite of that, there is a very blatant obstruction of the entire process. And I hope that the courts come very heavily on this. So I hope that at least now, before the elections, there is some clarity about the entire matter, and that Mamata Banerjee is not able to use this kind of force, this kind of blatant force to use her offices like the police, and all her entire machinery is being used very indiscriminately to make sure that she keeps winning elections every time. She's obstructing the SIR process. She obstructs every investigation possible. Every time there is a standoff between the CBI, the EDs, so all of them, she has always obstructed any and every central administrative offices. So I think that the Supreme Court and the High Court, the courts must come down very heavily on her. And I am sure that this thing about the bullying will be very blatantly rebutted by the ASG.
All right. Well, we are learning now that Senior Advocate Menika Guruswamy, is of course appearing for the TMC, has told the court that they don't know what the ED has filed before the court. They just to be protected. That is the basic premise of what the TMC's advocate is saying, Vinny Jindal, in court.
Look, this is something, this is again something like putting forward a vague kind of thing, because if you are talking about a particular data, you can when this raid was conducted, you have appropriate places and appropriate way to stop this particular thing. But instead of going this, you have lodging and 4 FIR against ED people. The persons who has been using their constitutional right, they are legally making that raid. And what you are doing, you are trying to obstruct that people who has been constitutionally and legally bound to do it. The investigation you have been trying to influence, and you took all the documents which they have been collected. So it is just a vague argument again.
Yes.
They have their own ways. And I think this is a very bad precedent put forward by the...
Sambhav Sharma is also live with us on this story. Sambhav, what is the latest you can share with us from the courtroom?
Well, absolutely, a detailed hearing is going on as we speak in the Calcutta High Court, where Senior Advocate and Additional Solicitor General SV Raju is making submission for the Enforcement Directorate. And when it was asked that who is the counsel for the Union of India, SV Raju is saying that I am for the Union of India and the Enforcement Directorate in this particular case. And a detailed hearing is going on in the Calcutta High Court, and as you rightly pointed out, certain arguments where Senior Advocate Menika Guruswamy and ASG Raju has exchanged word over who will argue first. So this is what is going on in the courtroom, because Additional Solicitor General SV Raju is appearing virtually, and also here other advocates like senior advocate Menaka Guruswamy is also appearing virtually for Trinamool Congress TMC. And there is a war of words as it happens in the courtroom. Likewise, it's happening in the Calcutta High Court as we speak, where ASG SV Raju and Menaka Guruswamy is exchanging words over who will argue first. And judge said that let SV Raju, let me hear Additional Solicitor SV Raju is appearing for the Enforcement Directorate. And earlier, initially, when the hearing began at 2:30, important argument made by Enforcement Directorate, as Enforcement Directorate has said in the Calcutta High Court, that a similar kind of petition is already being moved in the Supreme Court, and there are 2 petitions moved in the Supreme Court. And so far, no hearing in the top court happened in this particular case, because on 14th, there was a hearing scheduled in the Calcutta High Court, and this particular hearing is going on in the Calcutta High Court.
Okay.
Now, it is to be seen whether the Calcutta High Court continue hearing the matter in detail on the merits, or it let the Supreme Court interfere finally and let the Supreme Court hear the matter in detail. It is to be seen, and these questions, the big question as to who will hear this particular case in detail will be clear in coming few minutes, like 15 minutes or 20 minutes. The hearing, it will be clear as to Calcutta High Court will hear this case in detail, or the Supreme Court, the top court of the country, will hear this case in detail.
All right. Well, in more news now coming in this hour, senior advocate Menaka Guruswamy has told the court that the TMC is not before the Supreme Court on caveat. She's told the court, we request that our data be protected and not used against us. Meanwhile, Additional Solicitor General SV Raju has claimed in court that every second his mic is being muted. So the obstruction continues. R.K. Singh, Supreme Court advocate, is with us. Supreme Court, beg your pardon, R.K. Singh, the Kolkata High Court, of course, hearing this matter. Once again, the ASG claiming his mic is being muted every second. Earlier too, he had claimed that other parties in this case, the Union of India and CBI, were being obstructed as well.
Thank you. Thank you very much. It's good that the hearing is going on, but the sad part is that there is still interruptions, as Raju is claiming, that is being obstructed, mics are being off. So these are the things which is giving the entire proceeding a sense of ambiguity. And this is not good for judicial propriety, which the lawyers there must take this thing into account, that judiciary is free from any kind of bias, and proceedings should not be disturbed at any level, first. Secondly, I have got a different take on it. I really do not know, although there is no bar in it, but the judicial propriety says once the matter is before the Supreme Court, although hearing has not been done, ideally, Calcutta High Court should not have proceeded with this matter at all. They should have waited for Supreme Court to go into it, because I'm repeating it. There is absolutely no bar on it, or there is a stay that the High Court will not proceed with it. But the judicial propriety and convention in this country is that when a senior court or an apex court is seized of a matter, generally subordinate courts like High Court and other courts should refrain from proceeding with the matter. But the matter is going on there, and the best part is that both the lawyers, both the sides, they have entered into an appearance. But the sad part remains that the allegation of disruption is there. And these are the things which really mandate Supreme Court to take notice of it as soon as possible and get the matter listed for hearing. Reason being, these are the things which is what is happening in Calcutta High Court. It is giving the entire judicial process a sense of, I am repeating for the sound of being repetitive also. That is ambiguity. And for partiality and impartiality, these are not good things. Yeah.
Okay, let me also ask you then, R.K. Singh, because what we're hearing is that, Menaka Guruswamy, who's representing the TMC government, has said that they are not before the SC on the caveat. I think the ASG had said earlier that similar prayers were being made in the Supreme Court. It's almost the same, the petitions, which is what is reference to what you were saying, that the Supreme Court only ideally should hear this case and not the High Court currently. But Menaka Guruswamy is saying that the TMC is not before the SC on caveat, and also repeatedly reiterating, we don't know the ED's prayers or petitions or details, we just want our election data safe.
No, fair enough. We do not know because what has come out in media that TMC is there on the caveat. But if Menka is saying so, then we have to believe her that TMC is not before the Supreme Court in caveat. But still, being present there in caveat or not, that is a different story. But once the matter is filed and the Union of India and ED both have filed an petition there, I believe Supreme Court will not pass any adversarial order or any order affecting any of the parties until Supreme Court hears both the parties. So filing a caveat or being on a caveat is immaterial. So that is not a big concern. My only concern is that judicial propriety must be maintained, because the news coming from Calcutta is a disturbing news for judicial fraternity. And this is not the manner in which a judicial proceedings should proceed on. If this continues, this disruption continues, then it is going to give enough reason to Supreme Court to get the entire matter transferred from Calcutta to a different High Court. Because ultimately, if the lawyers are not allowed to represent the case, then what purpose the judicial proceeding is having? So these are the reservations as a lawyer I have. And I am sure Supreme Court is going to take notice of all these things.
Okay. Let's quickly address some more breaking news coming in. The TMC Council has told the court now that the respondents, that is the ED, are known to leak data to the media. They've stated that such history makes them more apprehensive since they are engaged in sham search and seizure to take their data. So more details emerging. The Council of the TMC, of course, hitting out at the ED as well in this fresh argument. Sambhav Sharma.
Well, absolutely. Here, arguments and counter arguments are being made as we speak, and there is a live streaming link available through which I'm also hearing this Calcutta High Court, this courtroom's hearing. And here, Additional Solicitor General S.V. Raju is making statements, on behalf of Enforcement Directorate and Union of India as we speak. And you rightly pointed out, there are many other councils as well who are making the submission. One of the council is questioning Enforcement Directorate's role in this particular case and the raids conducted by the Enforcement Directorate. On the other hand, Additional Solicitor General is saying that there is certain kind of intervention being made, and I am not allowed to speak what's there in my mind. So ASG is complaining the court as to, court should allow ASG, who is appearing for Enforcement Directorate and Union of India. And on the other hand, there is also this question of data leak being discussed in the Calcutta High Court. As the hearing is unfolding, things will be clear in coming 10-15 minutes as to what important remark the Calcutta High Court is going to make, because it's a crucial hearing. All eyes are on the Calcutta High Court currently hearing this particular case, and another council is questioning the fundamental right being violated by certain kind of writ petitions being filed, and also and it was alleged that there was a theft of election-related data of the petitioner by the respondents. So these are the arguments being made in the Calcutta High Court as we speak. And also, it's crucial because initially itself, Justice Subra Ghosh, who is hearing the single judge bench of the Calcutta High Court, Justice Subra Ghosh, who is hearing this particular case, has observed that prayers made by the Enforcement Directorate before the Supreme Court appears to be almost identical, as in the one prayer which was made in the Calcutta High Court and another prayer later on Enforcement Directorate moved the Supreme Court. So both prayers seems to be identical. This was the question of the single judge bench to the Enforcement Directorate. To this, Additional Solicitor General S.V. Raju, who appeared for Enforcement Directorate, has said that the central agency has filed 2 petitions in the Supreme Court and both contains the same prayers. Now it is to be seen whether the Calcutta High Court will continue hear the matter in detail or let the Supreme Court interfere and let the Supreme Court hear this case, because there are 2 petitions of the Enforcement Directorate, as ASG is pointing out, in the Supreme Court, and 1 petition in the Calcutta High Court, and almost both petitions are similar.
Yes.
And another.
All right. Now, yes, more details also emerging. The High Court bench has stated that the TMC is primarily petitioning for the protection of data To this, ASG SV Raju said the record which was seized was taken by Mamata Banerjee. She seized all devices and records. Unless she is made a party, these prayers in this petition is not maintainable. This was abetted by the DG of Police and other officers. So unless she is made a party, this petition is not maintainable. He is also asserted that no record was taken by ED. Jasmine Damkewala, AOR Supreme Court, is with us as well now. Jasmine, more details of the hearing coming in. The TMC counsel stating this is all about data. That's what the High Court bench also is saying. It seems that the TMC, the West Bengal government, of course, is arguing on data being stolen allegedly. But once again, ASG Raju saying no record, no data, no election record was taken by the ED. He's also said that Mamata Banerjee should be made a party in this case. Otherwise, this case is not maintainable.
So, we hear the news coming in where there are requests for Mamata Banerjee to be made a party. We've heard of petitions being filed with identical players before the Supreme Court and the Calcutta High Court, basically for data protection. Now, instead of making a person a party, there is no legal immunity that is. There is no legal immunity to the Chief Minister. This is, as chaired by the President or the Governor, they have legal immunity. Chief Minister doesn't have legal immunity. However, whether the Chief Minister should be made a party to the present proceedings, made an accused in the matter, will have to be examined. A person who is necessary to come before the court to say lead evidence or put forth things can be made a witness also. In fact, if you make the person an accused, the person is not even bound to lead evidence. So, how much of a use that will make, making Mamata Banerjee a party to the proceedings, I do not know. But if the learning, we do not know the nitty-gritties of the matter, we know only what we read. But if the learned ASG is of that view, then we may be having a thought process. However, we have to keep in mind that the minute you make a person a party, you take away your power to get them to lead evidence. You can't put them in the box and cross-examine them. You cannot summon them as a witness because the person can't be summoned as a witness against himself. So if you need the necessary material from the party, from a particular person, rather than making a party, it may be a better option to make them a witness. But we leave it to the wisdom of those who are prosecuting the matter.
All right, and further breaking news also now coming in. ASG SV Raju is questioning the TMC's absence at the High Court. He's told the High Court the petition is filed by a stranger. Kindly look at who the petitioner is. How does he become acquainted? He was not there at search. Petitioner is All India Trinamool Congress. He's authorized signatory. Where is the authority? So now another point being brought forward. Radlakshmi Joshi, ASG SV Raju questioning the TMC's absence at the High Court.
Yes, absolutely, Uday. There are a lot of points on which the ASG is rebutting very strongly all these charges made by the TMC and their counsel. So, very frankly, like it was being said earlier, that the office or the house of the IPAC owner, the founder that was being raided, they are a different entity, and TMC is a different entity. So what the ASG is essentially saying is that the affidavit states some other people, and that the people who raided and the people who seized all the documents are, they're completely different. And also that, the documents, he's also talking about how the person who has made the affidavit, he's saying, for his knowledge. So he was not even present during all these proceedings. So then how can he actually be a true petitioner? So that, this is a technical point. And also that, another point is that the documents that were seized were of IPAC. And how TMC comes into the picture, I think that needs to be clarified. That is another technical point to there that can go very heavily against the TMC. So I think that the TMC has gone way beyond their limits in trying to seize all these documents. And also there's an entire list of police officers who have tried to obstruct this process.
Right. Big developments now coming in. Additional Solicitor General S.V. Raju has made a big claim at the High Court. He stated that the TMC has filed a false affidavit in court. He's questioned the TMC representative that filed the petition, stating was he present when so-called material was seized. He says, facts true to my knowledge, this is a false statement on oath. He was nowhere in picture. I am showing that the TMC representative has filed a false affidavit. He had no knowledge about the search or seizure. He says this is true to his knowledge, but the fact is that Section 17 PMLA powers are pending before the Supreme Court. So big developments coming in. RK Singh, ASG claiming that the TMC has filed a false affidavit in court.
Yes, I am hearing from you only because you have been doing live reporting, and this is a very serious offense. And if he is alleging something like that, that they have filed a false affidavit, then it is certainly going to change the entire course of the hearing, because it is coming from no less than top government officials, and that too who is representing Enforcement Directorate. If this allegation is made orally, I will expect that this allegation is they are going to make through the affidavit also. And once it has come, then it is going to change the entire course of the hearing. And if it counts to be true, then certainly the other side is in for a big trouble, big trouble, and an all-time big trouble. But having said that, again I am repeating it. High Court, I have given the chance to understand that the High Court is going into the merit, because the manner in which the submissions are being made by both the sides, it seems that High Court is not only looking into the maintainability, but is also going into the merit of the entire case. And especially when the matter is seized with Supreme Court, giving such a detailed hearing, that leaves many a doubt. Suppose tomorrow High Court gives a finding and Supreme Court contrarily finds automatically, I mean, they are going to say it or they are going to confirm it. But judicial propriety, again, I am saying it should not go in for such a lengthy hearing. And the High Court should have waited for the Supreme Court to make a hearing of it. But what one can do, reason being the hearing is going. So we have no other choice than to wait and see what the judges, I mean the Honorable Judge, observes. Yeah, please.
All right. In fact, let me go back to Sambhav Sharma for more details on this story. Sambhav, further details, of course, emerging now from the Kolkata High Court. The Kolkata High Court continuously, of course, hearing this case. We are breaking down the latest details for our viewers. What can you share with us? What is the latest assertion being made by the ASG in court? All right, more breaking developments coming in now. Additional Solicitor General S.V. Raju has told the Calcutta High Court that the concerned raid had nothing to do with the TMC, and the person who was raided by the ED has not come before the court. He's also said that the TMC representative who filed the petition must state his source, as he was not present at the time of the raid and therefore cannot state things from his knowledge. So assertions being made, Joyita Basu, by the ASG in court, saying that the raid was not anything to do with the Trinamool Congress or election data. Also stating that the person who's come before the court was not present at the time of raids. And how is he then speaking, given the fact that the person who was raided is not before the court?
Well, the thing is that, first of all, I think there is a case of Mamata Banerjee saying something about her personal papers were there. Is that the case? Yeah, because frankly, listen, what we need is that in a case like this, instead of getting stuck in the political, I would say, whirligig, it's better that, these cases get settled apolitically. And frankly, whatever Mamata Banerjee did that day, it's utterly reprehensible. It should not have been allowed something like that. How is it in which other state the chief minister goes rushing at the place of an ED raid and starts recovering papers from there? What was she trying to hide? So you see, I mean, we may get caught in these things about, procedural discrepancies maybe. But the fact of the matter is that why is the chief minister so desperate? Okay? Why was the ED raid not allowed to be carried out? Why is it that whenever it comes to West Bengal, that every case has to everything, whatever the central government or anybody else for that matter wants to do in that state. For everything, every case goes to the court. I mean, what kind of, powers, extra constitutional powers does the Trinamool government have that this happens?
Okay. All right. Well, more news, of course, also emerging now from the hearing. The hearing, of course, is continuing in court. Sambhav Sharma, I believe, is back with us for more details on the hearing. Sambhav, what's the latest that you can share with us?
Well, here detailed arguments are being made by the Additional Solicitor General, who is appearing for Enforcement Directorate, and ASG is claiming the seizure of the records and devices were taken by Mamata Banerjee, and ASG has said the petition is not maintainable unless Mamata Banerjee is made party to this particular case. So here ED by Additional Solicitor General S.V. Raju in the Calcutta High Court is saying that Mamata Banerjee should be made the party to the case. The sitting Chief Minister of West Bengal should be made party in this particular case, is what ASG is submitting for Enforcement Directorate. And ASG asserted that no records or devices were seized by the Enforcement Directorate.
Yes. Jasmine Damkewala also with us now. Jasmine, more details from the Kolkata High Court coming in. Your response to, of course, some of the assertions being made by the ASG. Also, the fact that the ASG has, of course, made that explosive charge that the false information is being put forth by the TMC counsel in court, also claiming that people who actually should be parties in the case or were at the spot are not coming before the court, which is why this petition is not really maintainable.
That is right. Because the person who can come to court, who can file a petition, it should be the person who agrees or the person who is directly involved in something. It cannot be like a representative criminal proceeding, cannot be representative proceedings that somebody else files on somebody else's behalf unless court permission is taken. There is no explanation why the concerned person who was on the spot are not coming forth before the Honorable Court. Mamata Banerjee was personally there during the raid, which she was, we believe, as per records, is actually quite a shocking thing because, that is not something that happens in any state. Now, if it has happened, then yes, she is directly answerable. But yes, again, I will say the same thing, whether to make her a party or not, and whether she wants to personally file herself or not, is her distinction. But whether the court can examine the fact whether Trinamool Congress could have maintained this petition or not, and if they could not, that it can be thrown out. Whether Mamata Banerjee wants to be personally a petitioner or not is a very different story. That you can't force anybody to be a petitioner. You can make them a respondent, you can call them an accused, you can reject a petition which is not filed by a person who is properly authorized or directly in the know-how, because they cannot lead evidence. A person who is not in the know-how. The know-how can be on the basis of being an eyewitness or formal official records. So if they state that this is on the basis of formal official records that they have, which are properly in their control, and it's on the basis of information received, then a petition is maintainable. But if it is filed on the basis of knowledge, that I have knowledge, then it has to be first-hand knowledge. It cannot be third-party hearsay. So that is the test the Honorable Court will have to see. If it is on basis of records and proper paperwork which is handed over, which they are entitled to, then it is maintainable. Otherwise, not. It cannot. The petition cannot be maintainable on hearsay.
Okay. More breaking news, in fact, coming in now. The Calcutta High Court bench has told the ED counsel that the defect in the TMC's petition was cured in a supplementary affidavit. To this, the ASG appearing for the ED has apologized to the court and moved for the particular matter to be adjourned. The ASG has stated before entertaining the application the defect must be cured. That cannot be done in this case because it was a false affidavit. The person who filed the affidavit was not concerned or present at the place of the search. So the ASG trying to say that this petition is not maintainable. It's a bit infructuous since the person who filed this was not concerned or present at the scene. Also, a false affidavit has been filed before the court. That's once again being reiterated by the ASG. Sambhav Sharma.
Well, absolutely detailed argument is being made in the Calcutta High Court. ASG making submission, but the point which you are making here is very important. It's about the particular petition.
And the High Court bench has said that there was a defect. They've agreed that there was a defect, but they're saying possibly it's been cured in a supplementary affidavit.
Well, absolutely, but the court has also made it clear that it will hear the other side on the maintainability of the issue, and the ASG has said that if you don't want to hear me, to this the court said, please confine to your submissions. So here the submissions which could be a bit open-ended, here the court is saying again and again, reiterating that the submissions should be on the main, or should be confined to the important aspects, not open-ended submissions. And there must not be any war of words in the courtroom among lawyers. But when it comes to curing this particular petition, ASG has said before entertaining the application, the defects must be cured, and that cannot be done in this case because it was a false affidavit. And the person who filed the affidavit was not concerned and not present at place of the, or present at the place of the search. The person who filed this detailed affidavit. In a way, again, ASG, SV Raju, is pointing out to West Bengal Chief Minister Mamata Banerjee and saying that she should be made party to this particular case rather than the Trinamool Congress, the TMC. ASG has said very clearly that the raids had nothing to do with TMC, and the person who was raided by the Enforcement Directorate has not come before this court. This is very important submission of Additional Solicitor General. However, the court has asked that, kindly make your submissions crisp and precise to the point. And ASG is saying, and I quote, that you may record that you are not letting me argue. I know my limits. If you want to nip me in the bud, I will go down. This is what the ASG is saying to the Calcutta High Court, the single judge bench of the Calcutta High Court, which is hearing this case, and heated arguments being made in the Calcutta High Court as we speak. And a very important argument by the Enforcement Directorate is that what is the point of this affidavit by a person who is not even the party to the case, and the person who should be made party to the case is the West Bengal Chief Minister. And this is very important argument of ASG. Now it is to be seen what the Calcutta High Court says next to this particular argument of the ASG.
Well, in further news coming in, the High Court bench has asked the Additional Solicitor General if there is nothing further on maintainability at the moment. To this, the ASG has responded that he is still making his point, asking the court to look at Section 17 of the PMLA. The court has stated they are not hearing that matter now and will first hear the other side on the issue of maintainability of this petition. So the issue of maintainability currently being discussed, Jasmine, saying that if there's anything further on maintainability, then the ASG must put just that out, and then the other side will also be heard on the maintainability of this petition.
Yes, that's right. So that is a proper principle of law which is being followed, because maintainability, when a petition is filed, the first test is maintainability. If the objection is raised on maintainability, if no objection is raised, it goes on the merit. If the objection is raised on the matter of maintainability, then the maintainability aspect is to be tested first and order has to be passed on that. Once that threshold is crossed, then you can go to the facts of the matter. Now that we know a little better about the affidavit, in case the deponent of the affidavit has stated that this is as per affidavits are in proper normal format. And the format says this is as per my knowledge and belief. If this is as per my knowledge and belief, then it has to be as per knowledge and belief of the deponent. If it is as per records, then it is as per records. If a deponent has said that this petition is being filed as per my knowledge and belief and led submission in the petition and the affidavit to the effect that he was like as though one would believe that he was there, because it is as per personal knowledge, and actually he did not have the knowledge, then that is not a defect you can cure. There are curable defects, there are incurable defects. False affidavits are not curable defects. The petition has to be rejected at the threshold, apology has to be tendered, and then the rest of the matter is one can see whether a fresh affidavit will have to be filed or not, but it's not a curable defect.
Yes, let me in fact quickly take that back to you, Sambhav Sharma, on of course the observations as well. Now the bench also reportedly has been making certain observations, a pretty fiery exchange between the bench and the ASG as well. What else has the bench said? What else has the judge said in his observations, the latest observation?
See, I track courts all the time, but here this hearing is different from many earlier hearings where I saw Additional Solicitor General S.V. Raju appearing for parties. I've seen him appearing in Rouse Avenue Court of Delhi and in many matters in the Supreme Court. But here, this exchange between bench and ASG is is different. Here the ASG has now said that he will explain the Enforcement Directorate's power under Section 17 of the Prevention of Money Laundering Act. And ASG has further said the court that the issue under Section 17 of FEMLA being examined by the Supreme Court. But again, the court stops ASG and says that he is spending time on an irrelevant issue. And it's a big statement by the court. My court is saying that court is stopping ASG and saying that he is spending time on an irrelevant issue.
Okay,
So
more news coming in now. The ASG has asked the Calcutta High Court to reject the petition, stating it is vague and the power to seize flows from Section 17 of the PMLA. However, the court has asked him not to make these submissions now. The High Court bench stated, we are not dealing with Section 17 here. We know the Supreme Court is seized of this issue. Jasmine Damkewala is with us on the broadcast. Jasmine, now the ASG asking the Calcutta High Court to reject this petition, saying it's vague, and also of course delving on Section 17, but the bench saying they know Section 17, we're not dealing with it, we know the Supreme Court is seized of that issue, but make relevant arguments only.
So essentially, Section 17 is the primary section in PMLA. Now, if a petition has already been filed before the Honorable Supreme Court and the Supreme Court to seize of it, a High Court cannot pass parallel orders. A matter can be examined only by one court at a time. So, when the matter is now directly at the Honorable Supreme Court, submission cannot be made, the order cannot be sought on that very Section 17 pleading before the Honorable High Court. That is one aspect of it. Second aspect of it is the relevancy is a very relative term. What may be relevant here may not be relevant before another court. What may be relevant today may not be relevant tomorrow. So, what the Honorable Court is essentially saying is that Section 17 that the Supreme Court is examining, it is pending before the Honorable Supreme Court. So, you can't parallel argument here. It is not relevant to the matter today and here. That is what it means. So, essentially, they are examining on maintainability. Honorable Calcutta High Court wants to pass orders on maintainability and then start other necessary orders in the matter, rather than going to the merits which are pending before the Supreme Court.
Ashwini Kumar Dubey, AOR Supreme Court, also is joining us now live. The arguments continuing thick and fast in this hearing in the Kolkata High Court. Ashwini, what do you make of what has been said so far?
Uday, Section 17, as you say, and as the court is observing that it is Supreme Court has seized with the matter, and therefore hearing on that and repeatedly asking about the Section 17 would not be a legal and tenable argument. So court is time and again resisting and asking the ASG not to argue on that point. So the ASG said that this Honorable Court does not want to hear me, and I have not finished. The person who has filed affidavit is not concerned or present at the place of the search. These are the basically general arguments are being done, but the moot question is whether the raid conducted by the ED at the premises at various locations on January 8 and subsequently, and that to the Chief Minister's involvement in taking away the papers, will be justified and appropriate, keeping in view the law of the land, number one. Number two, whether the power vested with the ED under the PMLA is absolute with respect to the raid and the proximate link of the money, hawala money or hawal transfer or proceeds of crime at different location and at this given address is appropriate, right, and in consonance with the law, as is being said by the Trinamool Congress and the state West Bengal Chief Minister that the ED is acting in a partition matter. So the court will hear and pass this order. Rest of the issue, so far as the section 17 of PMLA is concerned, that is already seized with the Supreme Court. So very interesting hearing going on. Let us see how the court says, because the ASG is saying that the petition is not maintainable and therefore the Honorable High Court should dismiss this petition. And so far as the affidavit is concerned, that the ASG has also raised that it is not being filed by a relevant person or person aggrieved who has any who is related with the subject matter. So court has also not considered that argument. So what the final outcome would come, that would be the wisdom of the Honorable
Court. All right. Now the ASG has responded to the High Court, stating two arguments are made. One on ED's past to seize and sensitive documents were seized. Both are before the Supreme Court. However, the court has told him that the TMCs only asked for preservation of the allegedly political data. To this, the ASG has told the court that nothing was seized by the ED, and so how can the issue be maintained? The ASG asserted ED has not taken anything. Mamata Banerjee took away the data. We don't have possession of anything. Sambhav Sharma. Or I think we've lost some of the Jasmine Dhamkewala with us. Jasmine. So on data, of course, the bench putting forth a direct question on